Hi, my name is Emilia A. Kagampang, and I will be discussing to you the case of Leonardo versus Court of Appeals. Francisca Reyes died intestate. She was survived by her two daughters, Maria and Silvestra Kailes, and her grandson, Sotero Leonardo, who was the son of her late daughter, Pascuala Kailes, who predeceased her. Sotero and Silvestra died without any issues, leaving Maria, the private respondent, as the sole heir of Francisca Reyes. Petitioner Crescenciano Leonardo, claiming to be the son of the late Sotero Leonardo, filed a complaint for ownership of properties, sum of money, and accounting. He wants to be declared as one of the lawful heirs of Francisca, entitling him to one half of the share of the estate between him and Maria. He also wants to partition the properties between them and hold an accounting of all income derived by said properties and have his share delivered to him with legal interests. Maria asserted exclusive ownership over the properties and held that petitioner is an illegitimate child who cannot succeed by right of representation. James, another private respondent, asserted ownership over the property by virtue of a valid and legal deed of sale by Maria. The court of first instance held for the petitioner, while the CA reversed and dismissed the case. There are three issues in this case. The first one is whether or not the properties in question are exclusive properties of private respondents. The Supreme Court held that yes, the two parcels of land were bought by Maria Kailes under a deed of sale. After declaring it in her name, she paid the realty taxes starting from 1917 up to 1948. Thereafter, as she and her son Narciso Bracewell left for Nueva Ecija, Francisca Reyes managed the two properties and paid the realty taxes of both lands. However, for unexplained reasons, Francisca paid and declared the same in her own name. Because of this, the petitioner decided to run after the properties, erroneously thinking that as a great-grandson of Francisca Reyes, he had some proprietary rights over the same, as it allegedly represents the share of his father. For the second issue, whether or not the petitioner has established his filiation, the Supreme Court held that no. Petitioner submitted in evidence his alleged birth certificate showing that his father is Sotero Leonardo, married to Socorro Timbol, his alleged mother. However, the CA found that the name of the child described in the birth certificate is not that of the plaintiff but a certain Alfredo Leonardo, who was born on September 13, 1938. Other than his bare allegation, the petitioner did not submit any durable evidence showing that the Alfredo Leonardo mentioned in the birth certificate is no other than himself. Thus, petitioner failed to prove his filiation, which is fundamental requisite in this action, where he is claiming to be an heir in the inheritance in question. For the third issue, whether or not the petitioner as great-grandson of Francisca Reyes has legal right to inherit by representation. So the Supreme Court held that no. Supposing that petitioner is a child of Sotero Leonardo, still he cannot, by right of representation, claim a share of the estate left by the deceased Francisca Reyes, considering that, as found again by the CA, he was born outside of wedlock, as shown by the fact that when he was born on September 13, his alleged putative father and mother were not yet married, and that as his alleged father's first marriage was still subsisting. At most, the petitioner would be an illegitimate child who has no right to inherit ab intestato from the legitimate children and relatives of his father like the deceased Francisca Reyes. Thank you for watching.